Hello and welcome to the Minimum Competence episode for Thursday, June 26, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, a judge blocking Trump's Job Corps shutdown, Meta winning an AI copyright case, and my Forbes piece on the IRS's strained but successful 2025 season. Let's remember, it is difficult to get someone to understand something when their salary depends on their not understanding it, and read today's legal news. On this day in legal history, June 26, 1996, the U.S. Supreme Court issued its landmark decision in United States v. Virginia, striking down the Virginia Military Institute's male-only admissions policy. The 7-1 ruling held that the exclusion of women violated the Equal Protection Clause of the 14th Amendment. Writing for the majority, Justice Ruth Bader Ginsburg emphasized that gender-based government action must demonstrate an exceedingly persuasive justification to be constitutional. VMI had long argued that its adversative military-style education would be compromised by the inclusion of women. In response to the lawsuit, Virginia created a separate program for women at Mary Baldwin College, which the court found to be inherently unequal. The court concluded that Virginia failed to show that its gender-based admissions policy was substantially related to an important governmental objective. Justice Ginsburg's opinion stressed that generalizations about gender roles cannot justify the denial of opportunity. The ruling did not require VMI to change its core program, but made clear that women must be given equal access to it. This decision marked a significant moment in the legal evolution of gender equality and helped to dismantle one of the most visible public institutions that had resisted coeducation. Justice Scalia dissented, arguing that the decision imposed a rigid standard of gender equality that went beyond the Constitution's text and history. Nevertheless, the ruling reflected the court's growing skepticism of laws that enforce traditional gender roles. United States v. Virginia remains one of the most cited gender discrimination cases and is considered a hallmark of Ginsburg's judicial legacy. A federal judge has extended a block on the Trump administration's attempt to dismantle Job Corps, a long-standing job training program for low-income youth. U.S. District Judge Andrew Carter ruled that the Department of Labor's plan to abruptly end the program without congressional approval likely violates federal law. The decision came in response to a lawsuit filed by the National Job Corps Association and several of its contractors. Job Corps, established in 1964, provides educational and vocational training for disadvantaged individuals aged 16 to 24. It currently serves about 25,000 participants at 120 centers nationwide, with an annual budget of $1.7 billion. The administration argued the program was inefficient, citing low graduation rates, poor job placement, and issues with violence and security at centers. However, plaintiffs maintain that only Congress can terminate a federally funded program and that the Labor Department failed to follow statutory procedures for closing individual centers. Judge Carter agreed, stating that once Congress mandates and funds a program, the executive branch cannot unilaterally terminate it. A federal judge in San Francisco ruled in favor of Meta Platforms, dismissing a copyright lawsuit brought by authors who accused the company of using their books without permission to train its AI system, Llama. U.S. District Judge Vince Chabria found the authors failed to show sufficient evidence that Meta's AI training harmed the market for their work, an essential element in proving copyright infringement under U.S. law. While Chabria emphasized that unauthorized use of copyrighted works for AI training could be illegal in many scenarios, he clarified that his ruling was limited to the plaintiff's failure to present the right arguments or evidence. This position diverges from another recent ruling in which Judge William Alsup found that Anthropic's AI use of copyrighted content qualified as fair use. The author's legal team criticized the decision, calling Meta's action a form of historically unprecedented pirating, while Meta praised the outcome and defended fair use as essential for developing transformative AI technologies. This case is part of a broader legal wave in which creators are challenging companies like OpenAI, Microsoft, and Anthropic over AI systems trained on copyrighted materials. At the heart of the dispute is whether using such content without payment or permission to create AI-generated works constitutes fair use or undermines creative incentives. And in a piece I wrote for Forbes yesterday, I note the IRS managed an objectively successful 2025 filing season, processing nearly 138 million returns, most of them electronically, but also that success masks deeper structural weaknesses. While headline numbers are strong, the IRS suspended over 13 million returns, largely due to fraud checks or errors, delaying refunds and spotlighting operational vulnerabilities. One of the most glaring issues is the average 20-month wait time for identity theft victims to resolve their cases, many of whom are low-income taxpayers urgently awaiting those refunds. Staffing levels are at crisis lows. The IRS workforce shrank by 26% in the first half of 2025 alone, casting doubt on its ability to maintain performance as the temporary funding from the Inflation Reduction Act winds down. Looking ahead, the 2026 expiration of key provisions from the 2017 tax law will require major administrative overhauls, from updates to forms, updates to guidance, and withholding tables that the current IRS may be too under-resourced to actually handle. The agency has promising plans, including digitization of paper returns and case system integration, but even the best designed systems require trained staff to implement and maintain them. Moreover, modernization must be inclusive. 17% of Americans still lack internet access, and an effective IRS must serve them too. Ultimately, tax administration is not just a technical task, it's a distributive justice issue, and how we fund and staff it determines who bears the burden when the system falters. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, know that our liberties were not won without suffering and may be lost again through our own cowardice.